We're talking about depositions, in particular, how to present yourself at a deposition. And by that, I mean just basically how you present, how you look and speak at a deposition. I gotta preface this by saying, speak to your own attorney for advice. This is just informational, some of the things that I tell or suggest to my clients before their deposition. Deposition is very often the first and sometimes the only time that the other lawyer, or I should say even a representative of the insurance company, the party on the other side that will ultimately pay your claim, is getting a chance to see you face to face, to meet with you, hear from you. Almost as important as what you say in terms of your answers to questions, almost as important is how you say it, how you present. Attorneys are always making assessments of witnesses in terms of credibility, presentation, likability. Insurance companies really do not pay claims because they're trying to do what's fair or what's right or what's reasonable in the circumstances. The whole payment of a claim is to buy. It's an exchange of money to the injured person in exchange for a right. So the injured party is giving up the right to have their case decided by a judge and or jury in a courtroom. And so the insurance company will place a value on that right, what they're willing to pay based on what they think their risk is in proceeding all the way through trial. That's basically money, what their money risk is. Although the facts or the evidence are critically important, lawyers understand that the jury or the trier of fact, whoever's deciding the facts of the case, will also put a lot of weight on the presentation of the person. Are they likable? Are they honest? Do I want to find in this person's favor? So it's really important when you go to your deposition that you remain likable and you present well. So here's a couple of things you can do, a few things you can do to help your chances at deposition. Dress appropriately. You just want to look like you have respect for the process. As a general rule, dress like you would for a job interview. Look appropriate. You don't have to wear a suit. Show some respect for the process in terms of your appearance. The other thing is, do not argue with the other lawyer, the examining attorney. Reserve that for your own attorney to do. That's their job. They're there with you. And if the opposing counsel is offside, being rude or aggressive, maintain your composure. Let your attorney deal with those issues. Okay? Your job is just to convey the information as best you can. State the facts. If the other attorney's rude, let them be rude. Critically important, don't let them pull you into that state of mind. All right? You can take breaks if you feel like you're getting flustered, frustrated, nervous, whatever it might be that is undermining your ability to answer appropriately. The best bet, if in doubt, request a break. You're entitled to breaks. Now, there are some exceptions to that. If there's a question pending, the opposing counsel would be generally entitled to have the answer before the break. But with few exceptions, they're accommodated. Get some air so you can go back at it. Another important point, avoid sarcasm at all costs. Never, ever, ever be sarcastic. At the end of a deposition, we're left with a transcript. It does not pick up sarcasm. Your words will be taken at face value. It doesn't pick up the mood. It doesn't pick up the humor, any of that. So avoid humor, avoid sarcasm, stick to the facts. There's no such thing as off the record. Some opposing counsel, very likable and charismatic, you'll go off the record. You'll hear that. Time for a break or lunch or whatever. Off the record, you might say something because you find some similar interest between you and the opposing counsel. You guys might start talking about fishing or something. And even though it's off the record, I can almost guarantee any information you share with the opposing lawyer will probably be used against you once you're back on the record and it's being recorded. So if you do take a break, use it as a break. When you're back in to do your deposition, then it's all on the record. Don't exaggerate. Obviously, in preparation for your deposition, speak to your attorney about the evidence that you're going to give, but avoid exaggeration. It's usually obvious to the deposing lawyer that you're exaggerating, It undermines credibility. So a common question that clients ask is, do I got to be concerned with trick questions, or is the other counsel going to try to mess me up and trick me? And that's really the domain of your own lawyer. They're going to be seated right there with you. If it's not a proper question, that's the role of your lawyer. But also you be aware. So if you don't understand the question, if it's not clear to you what the examining lawyer is asking you, don't answer a question unless you understand it. If you don't understand, simply tell the lawyer, I don't understand the question. Most attorneys at the outset will tell you, if you don't understand my question, let me know, I'll rephrase it. If you don't hear my question, let me know, I'll restate it. So unless you've heard the entire question and unless you understand it, make sure you let the other lawyer know so that it can be either restated or rephrased. But in terms of beyond that, if it's a trick question, that's also a helpful way to alert your own attorney that maybe the question is convoluted or not clear. If your lawyer has anything to add, can add his own objection at that time. So these points really are more about your presentation, your likability, your respect for the process, your credibility, and not so much information about the evidence you're giving or the subject matter you're talking on. Keep in mind, these are just important points for presenting well in terms of a person that's likable. Because after the deposition, what the other attorney is going to do is they're going to write a report to their client, typically an insurance company. And that report will summarize your evidence, the facts, as you recall them, the evidence you're giving with respect to how the event occurred, the injuries, the impact on your life, etc. But also there's a big part of that report that talks about you as a witness. Are you likable? Are you credible? More importantly, will a jury find you likable and credible? Will they side with your version of events? Do your version of events sound credible, or are they exaggerated or don't make sense? That's almost as important, and sometimes in some cases might be more important than the evidence itself about the injuries, the impact it has on your life, because that evidence can be gathered through other sources as well. Your medical records will talk clearly about your injuries, your symptoms, the treatment, the diagnosis, etc. Your employment, if it's impacted, can come from employment records and coworkers and managers, but your own credibility, you're the only one in control of that. And so that's really critically important, that you want to make sure you present in a way that it doesn't hurt your case. Because what you don't want is the insurance company say, well, okay, it's an accident, but this person would be a terrible witness at trial. They're a below average witness. A jury will hate them. A jury won't believe them. A jury's not going to like them. A jury's not going to be favorable to them, because that could actually undermine the value of your case and cause an insurance company to offer you less money than you deserve. I hope you found this video informative. If you have any questions, feel free to reach out to us. We're available 24/7. We're happy to provide you with a free consultation. Thanks for watching.